these 2 points which emerge out of the in the official readings of customary law and the versions of customary law land recorded by Tom Bennett and others. The arguments that in the event of a landholder's death without a direct heir, the landlord would revert back to him for reallocation. The idea that land could not be transferred once it was allocated to an individual. Both of these were at odds with what I'd observed in the ethnographic field work in Curren and in my archival work in Bazana. This is what drove me to the question which animates this paper, which is how does the court system learn about customary law and what does it learn, what does it not learn, right? And the other point I want to make before I get started with the presentation is just that I use a lot of older terms here like Transkai, native, and so on. And my use of these terms is not endorsement by any means. It's a reflection of the historical circumstances under which the sources were written. So, without further ado, let me share my screen. And I have, after doing the recording, I decided to get the whole thing transcribed. So it should be, transcript should be in the right-hand side of the screen for everyone. No, I'm sorry, that's the presentation. Can you see the transcript as well?
Yes, we can, Derek. And you may start your record. You may play click on play at the bottom.
It's paused right now. Yes, I just paused it to make sure everyone can hear it.
Yes, we can hear you. We can hear. So you can just click on the play.
Great, thank you. Yeah, 1996, I wrote a dissertation proposal, which I indicated I was interested in the effects of the CPA Act, new land tenure policies in South Africa. I did not expect that these policies would remain unresolved and up to 26 years later. The talk today, though, focuses on some of the background to the current debates, notably the history of official engagement with the customary law of land and rural black land tenure going back to the late 19th century. I draw upon archival work in the Cape Town archives, covering the former Transkei, other areas of the Eastern Cape. I also see records in the Native Appeals Court. They've recently been digitized and made available online by the University of Pretoria. Let me thank them, as well as LARC, the LRC, and PLOS for welcoming me. Of course, the organizers for the opportunity to join this conference. The paper is about the process of legal scholars class attainment on one hand, the ways that legal actors come to know customary law, and ignorance on the other. How the information gathering and collection does take place also systematically produces a lack of knowledge and unwillingness to look further on the part of officials and other observers. The ignorance, I argue, may continue to the present day. If the processes described here had worked differently, we might have a very different agenda to this conference. Legal scholars have discussed the ascertainment of customary law at length, primarily with an interest in integrating it into the Western legal system. The Transkei in particular has been characterized by reliance upon early texts, notably the Cape Native Laws and Customs Commission of 1883. Biases in the ascertainment of customary law are generally considered as age and gender. Sean Rennie's work in the 1883 Commission notes that the commissioners, there were 2 years taking testimony, not interview a single woman, white or black. These profound gender biases and blindness pervade the material that I'm looking at. Having said that, though, I want to widen the scope of questions around the production of ignorance. In this paper, I consider 3 areas of evidence. The first of these is spatial. Where do court cases come from? Where do they not come from? What parts of the Eastern Cape are represented and which parts are not? How do these reflect different histories of engagement and resistance in the area? Second, I should look at the personnel, who actually provides information. Here I draw upon the archival records of the Native Appeals Court, and at the absence of so-called native assessors and the ways in which these other assessors, most frequently district magistrates from other districts, systematically contributed to ignorance. Finally, the third issue is the substance of the cases themselves. The Native Affairs Department and its governance of proclamation define land affairs as purely administrative, that is, outside the scope of the formal legal process and the Native Appeals Court. The cases upon which recorded law is based are not necessarily about land law at all. The cases which appear in the past pertain to trespass, inheritance, and so on. My spatial arguments relate to the political and the legal geography of the Transkei. Official versions of customary law are biased away from the areas in which living customary law around land tenure remain and is continued to remain most viable. I've shown this viability in prior work based on archival material from Bazana, far northeast of the Transkei, and throughout archival work in Plaha, the Central Coast. Overall, the coastal districts, culturally conservative districts of the Transkei, are underrepresented in the records in the appeals court, and hence in legal texts and customary law. So we're not areas where the focus of state intervention in land. This point can be illustrated by examining the implementation of betterment planning. Map 1 illustrates the state of betterment planning in the region in 1949. You can see that the coastal districts, the Transkei, had largely not been subjected to betterment. The absence of intervention along the coast was also reflected in the allocation of administrative staff in the region, as you can see from the table here. Reasons for this related to mundane matters like proximity to administrative centers and roads, but also the long-standing divide between more progressive school people, unlike Kavoka and traditionalist Reds, unlike Kawa in the region. It reflected administrative ideas about rural populations and a pattern of resistance to administration. Conditions also gave rise to spatial bias in what was recorded as official customary law. Cases from the region reached the Native Appeals Court were concentrated in areas with state intervention, titling, and access to lawyers. Moreover, the court records are underrepresented in areas where the state was less involved in matters, who might not have the money or transport to appeal. This map shows the distribution of cases from 1918 to 1929. 1918, you see the same pattern, right? Overall, then, the spatial pattern is clear, and as you can see, it's evidence of what was collected. If you look at Bennett's 2004 book on customary law in South Africa, none of the cases he discusses come from the coastal district of the Trans. The second area I consider here is the personnel involved in the courts. At the time of the 1883 commission and the decades immediately following, there appears to be considerable enthusiasm for and pride in the use of so-called native assessors. In subsequent years, however, magistrates increasingly thought of themselves being able to govern by the native custom without inquiring further into its content. And their use of assessors became very domain-specific, as they show. It became clear, though, that the position of an assessor is actually used for training of magistrates as a way to get additional magistrates' opinions on cases. You can see this discussion from the 14th annual conference involving the magistrates, the chief magistrate of Transkei Territory, the Native Affairs director, and so on. And the discussion following about the position as providing a training ground for young officers. Pause, give a second to read this in case the slide goes by too quick. The Assistant Chief Magistrate in his reply to this resolution noted that there are native assessors gave opinions on obscure points of native law. Apart from the President's opinion, there is that of the native assessors. And it's those we'll turn to right now, because those are the ones who actually might be able to be providing new information about customary law. Let me now turn to the native assessors. Based on the availability of documents, focus on a period of roughly 1905 to 1920. Very little is recorded about the native assessors themselves. We can learn that they requested and received an increase from 5 shillings a day to 10 shillings a day in 1914. The subsequent raise request in June 1920 was turned down, but other than that, not much is said in the archives. The case records, however, give a picture of their role. Approximately 1 in 5 cases was included reference to testimony of native assessors of 400 in this period. These cases, however, are limited in their scope. They all tend to be dealing with various types of customary debts and payments, compensation from bogey, performative circumcision, seduction fines, compensation for Batwala, compensation for pregnancy, compensation for marital infidelity, and so on. Even in this period in which the assessors were very active, they're limited to specific domains of custom, they're not involved in the question about land, as we'll see in a second. Land cases are extremely scarce in the Native Appeals Court records for reasons which I'll discuss in a few minutes, but there were a handful of cases in this period in which issues around land came up. One addressed the question whether plots can be sold, another addressed the appointment of an agent to cultivate for an absent landholder, and another pertaining rules of inheritance. But What's clear for all these is that the magistrate's points of reference in resolving them are the existing proclamations, not local practices or local opinions. He illustrates this very formalist approach to detect land matters. Case concerning a sale of plots came from Bazana, interestingly. Basically, you can see the reasoning here is entirely with reference to the existing proclamations. There's no effort to pursue any local opinions or local knowledge of customary law around land. Ironically, 30 years later, Ezra Postal writes to the Bazana magistrate with argument on living customary law, noting that people always made their own private arrangements as far as selling and buying sites are concerned. But this customary law was not recognized by the magistrates at all. Presence of the 1914 case suggests this was going on then as well, rather than draw upon local expertise to understand how tenure practice might be changing. So they chose to remain ignorant and ask about the intentions behind the predecessors' proclamations. So we've arrived at what I refer to as the substantive cases. This point hinges on the observation that land was considered to be a purely administrative and not a legal topic. What does this mean exactly? Act 143 of 1919 was one of many which spelled out the administrative treatment. Second reading these slides again. Treatment of land matters explicitly. Even though land was treated as a purely administrative matter, the cases that make it into the Native Appeals Court were cases which land came up in passing. There were cases that centered on land regulations and land allocation and so on inheritance, marriage and divorce, livestock trespass, and so on, which land rights may have come up in the course of proceedings in which land proclamations might have been touched upon. The limits of this imposed in practice can be seen by looking at the handful of I need to take a second to read the slides so cover the case content here. Of cases made through the Native Appeals Court addressed Act 143 of 1919 and subsequent years. In all of these cases, we see the production of ignorance. When land is treated as purely administrative, there's no need for the court to understand further. Likewise, the claims of widows and of other prospective heirs can be dismissed rather than heard in detail. Let me close this discussion with a passage from my paper on Mazana. These cases point to a larger issue. The customary law that has been recorded through the case law has been filtered by administrative and legal systems that actively discouraged assertions based on living customary law. The passage continues describing the implications from the point of view of local actors. For this paper, this presentation emphasizes this as one among several practices. Together with the spatial biases, the lack of engagement with native assessors on land issues, and the gender biases, together produce the system structurally uninterested in and incapable of ascertaining living customary law. All right, thank you all for that. That's my talk. I have some further thoughts on this, the question of ignorance and its production, and how we move forward in thinking about new policies, and design policies which enable the living customary law to be heard and more prominent rather than suppressed or just kind of passed to the wayside as it have in the past. But thank you all very much, and look forward to hearing comments and questions.
Oh, great. Okay, over to you. Thanks.
Sorry, I wasn't unmuted. Thank you very much for that, Derek. The second contribution to this panel is a paper on the municipal traditional authority interface in the governance of land under customary tenure in South Africa. It's a paper that's co-authored by Dr. Gaynor Paradza and Professor James Chikwizera. And it is Professor James Chikwizera who will be giving us the presentation today. And he is a professor from the Northwest University. Prof, are you there?
Yes, Chairperson, I'm here. Thank you very much for the opportunity. Session Chair, Nolundi Luaya. I would also want to thank my co-author from Paris, Dr. Gaina Paraza, and all the organizers of the conference and all the participants who are making it quite successful. Let me just try to share my presentation, Chair. Sorry, Chair, I think I can't see my presentation. Thought I'd put it on the desktop, but struggling to see it now when I want it. Let me try again the last time around. If I can't, I might ask you to help me.
What you can maybe do, sir, is that if you have your presentation, open it on your desktop and then come back to where you are right now and then click on the green button to press that says share screen, and then you just select that and then it'll pop up on the side.
Okay. I've done that. Where does it pop up now?
No, have your presentation open on your desktop as if you're going to be
Recording
presenting,
stopped.
and then just minimize it and then come back to the screen where you are right now, and then you press the green button in the middle over there. It'll say share screen, and then you'll see your presentation as one of the items there that you can share. Select that and then it'll come up here.
Okay.
Recording in progress.
Is my screen now visible?
Yes, it is.
Okay. Thank you very much, colleagues. And like what I indicated, I thank my co-author. And I would also want perhaps also to recognize and thank Prof. Mamdani for his excellent, presentation during the morning plenary, which really continued to unpack and make relevant the key issues and the contestations that we continue to have around customary land tenure systems in Africa and by extension in Southern Africa and in particular for South Africa. I would also want to recognize and in advance thank the organizers for also bringing our various, land activists and those also involved at the core face of the impacts of customary land tenure governance struggles, such as Sisi Margaret Molomo from Mokopane. I recognize here, and it's part of the case study that I will talk about, and I want to say it has been made easier because she was really able to hit the nail on the head and, unpack the issues that are linked to customary land tenure, especially with respect to mining developments and rights. And I would also want to recognize Water Speaker Mahlake from Bushbuck Municipality, who also did a fantastic job in terms of summarizing the nuances and current issues that do affect land governance in our traditional spaces. This is the presentation navigation. I will not spend much time on it, but in essence, I will run through some introduction, then the aim of the work that we're working on, the method that we have used, and then of course do some critical reflection on land administration in South Africa, but also speak with a specific focus on the PTO's a very interesting issue, which keeps remaining alive, but which is at the center of the key struggles and conversations around how we can improve customary land tenure processes and the systems of, security and livelihoods. Then I'll highlight some policy kind of directions. And of course, there will be concluding remarks and not a conclusion, because this is an active topic where we require to continue.
Sorry, Professor. Is it just our side, but your slides are not changing on our side?
Oh, they are not changing?
No. Have you moved on from the first slide?
Yes, I have moved on from the first slide. I'm actually on slide number 3.
Okay, so on our side, we're still seeing the cover slide. I'm not sure if others are seeing a different reflection.
Correct. We are still seeing the Prof. You must go into presentation mode, start slideshow, and start from. Click on slideshow, Prof.
Okay, fine. Let me do it the
Okay.
normal way.
Start from the
Slideshow
beginning. From the
from the
beginning.
beginning. There. You are seeing the first
Oh
slide.
no,
isn't it?
no. Now you see you got the. You have to swap screens because you got the on your screen now. We are seeing your PowerPoint. We don't see the presentation. Just stop sharing, Prof, and then you click on the share screen. Click on share screen now,
Sharing.
and then you see
Okay.
the one where your full screen, where you have the full slide. Share
Which one
screen,
should I
click on
take?
share screen,
Yes,
and
I'm.
then select the full screen. Where your PowerPoint is the full screen. Select that one.
This one or this one?
The one with the full screen where we don't see your slides.
Okay. Now I'm not so sure.
So
Okay.
I think maybe, there we go.
Oh no, that's now the wrong.
I
That's
think
the wrong one.
just for the sake of time, Graham, I think let's go
Yes.
with it.
Okay, do it like that, Prof.
Please do it like that, Prof. That's fine.
Sorry about that.
Perfect.
No, that's great.
Is it moving now or it's not moving?
Yes,
It
yes,
is
it's
moving.
moving. We're following with you.
Oh, okay. Thank you very much. This is the presentation navigator, where I was just highlighting that I'll cover the introduction. Then after that, also highlight, the method that we've used, a critical reflection on customary land administration in South Africa, and then also index our specific focuses on the PTO. I know there are a lot of discussions and conversations there, and a lot of different viewpoints, but you will see where we are coming from, quite exciting. And then there is just some discussion directions, and then we provide concluding remarks. And in terms of introduction, I will not reinforce, but we always find that land is a strategic livelihood resource, and it's actually a basis for livelihoods, especially for the majority in our rural and the communal areas, and also the marginalized. And it is fundamental because it's about sustenance, it's about resilience, it's about providing a shelter over your head, but it is also full of wealth or potential, which might also be hidden, such as minerals. And in that regard, you always find it's an intergenerational tool that we use and an asset for fighting disasters and actually rebounding after various shocks that might be extended to our communities. But most importantly, it's a form of identity and belonging. And then because of its centrality in our livelihoods, you find land governance involves stewardship from generation to generation, and in the process, it provides a platform for just or unjust, sustainable or unsustainable pathways of development. So then this always tends to filter in terms of the various forms of tenure systems, and in the process can either be undermining livelihoods or opening and strengthening livelihoods opportunities. And you find this becomes very critical when you look at our history, and the colleagues have spoken very well about where we are coming from, and how in terms of the legacy of apartheid, we had land tenure challenges with the Bantustans up until to today, and we are still working in terms of finding a way of how we can come out of that loop. And one could then hypothesize that unsustainable inherited land systems are not only volatile but are fragile, and are compromising the capacity of the rural spaces or rural areas to also complement and contribute to the economic growth and development of the country. Yet at the same time, we realize there is pressure on land resources that continues to mount, given a number of factors related or interrelated. It would be climate change, it would be the mining interests which are really coming to the fore, it could be general democratic increase, but also because of rising unemployment, and land also offers an opportunity for entrepreneurship and new ways or different ways of survival. You always then find it's important for us to focus on it because it can provide opportunities not only for resilience, but also refuge, and as well as spaces to go back and rebound after various forms of shocks and stresses that can affect you, be it whether you live in an urban area or in the rural area. And one of the key issues is that then when you look at that and you appreciate the context of the customary land tenure, you then start to realize that there are critical issues that we need to engage with in a very honest and sober manner, because that sector is quite vulnerable to conversion to formal and other alternative tenure systems with possibilities of disempowering existing land holders or land owners. And in terms of this paper, we looked at critically, exploring, administration of customary land tenure in South Africa on the basis of an evidence-based study. And of course, we're trying to understand how municipalities who represent the formal land governance and the traditional leadership or authorities who, through history, whether it has been tweaked or whether it has been reshaped for certain groups to have advantage, have been engaging in informal land governance or land support systems. And from there, we then highlighted what we believe are the planning and the policy vacuum levers that require strengthening or improvement as we look at the transmission of land, especially under customary tenure system. Then the research methods, I won't spend a lot of time on it, but it's the standard one where we looked at existing documents from the national, we looked at the National Spatial Development Framework, the National Development Plan, etc. Provincial, we looked at the relevant provincial development strategies. Then district, we then looked at, for example, land use schemes, spatial development schemes. We wanted to really understand statutes and acts. We also looked at all of them, like SPLUMA, Intergovernmental Relations Act, IP, ILRA, the Constitution, Municipal Systems Act. At the province, we also looked at the SPLUM bills in Mpumalanga and Limpopo. But at the same time, we also went to the localized SPLUMA bylaws for Bushbuck Ridge as well as a Waterberg municipality. And then, of course, we used a case study approach because there is no better way sometimes of understanding deeper nuances and granulated issues than going to the ground and then concentrating and soaking yourself in understanding what is happening. So fieldwork happened in Bushbuck Ridge as well as Mokopane in Limpopo province. And then, of course, we spoke with the different layers, town planners, central government, department representatives as available or accessible. The same with traditional leaders or authorities as available or accessible. And we based that thinking from in. Then in terms of customary land administration in South Africa, one of the key issues is we have the standard that we understand, and I will not spend much time on it, but we know individuals and communities hold various forms of individual and community rights, but these rights are not registered. We realize that we have this multiplicity of laws, statutory, cultural, religious, and family practice that always impact on how land is used. And because of all these diverse laws and practices, there's always ambiguity or contradiction or loopholes that are used by various sectors or by various also, spheres of government or various, power agencies. for advantage with respect to customary lands utilization. And then, of course, historically, we find customary land was mostly controlled by male traditional leaders or authorities who were exercising that control on behalf of the community, and the beneficiaries would then get conditions attached, which tended historically to differ by gender, but by now it's relatively, those lines are being blurred, they're going away. But we also then do find the issue of stewardship of that land has then become a contested area in this continually.
2 minutes, Prof.
improving.
2 minutes, please.
Okay, then these are the typologies given by Cousin, a fantastic, land development expert. And then you find we have role players that do come into play. And our conversations, as you see, they are linked on the bundle of rights. And these rights relate to how land is being allocated into different sectors. But our problem is customary land rights are not registered. Perhaps in terms of going towards the conclusion, what I would want to go into is to talk about the fact that we have wall-to-wall municipalities that gives local authorities the power, but traditional leaders have still continued to issue out PTOs for various reasons. And when we have big developments like shopping malls, which has been quite visible, especially in Bushbuck Ridge area, then you really do find some of those shopping malls are happening in areas under traditional leaders, and the negotiations are mainly between the traditional leaders and the investors, and this is happening to the detriment of rights for the customary, and traditional colleagues, as indicated by Tate, Speaker Mahlake. And I would then go to the discussion there. We still find we are still seated in terms of the continuum of land rights between informal and formal land rights, and contestations as to what would be the best way. And our argument is that there is a gap in terms of the process and a loophole, and there's a way to codify and secure the rights. And we believe there's a way to improve all the PTOs which were actually declared unconstitutional by the court and are either used in certain areas or are used by the traditional leaders, irrespective of the fact that they are unconstitutional, but to make the process then work to the benefit of the system. So in conclusion, Chairperson, we would want to indicate that areas under customary tenure system seem to be evolving towards statutory and formalized tenure, and we believe that in this regard we need to develop and improve the way of recording rights and systems of tenure systems in the rural areas to protect the livelihoods and the rights of the indigents. Thank you very much.
Thank you very much, Prof. Chakuzela. Thank you. A very rich presentation, and hopefully you'd be open to sharing those slides so that people can work through it. Colleagues, I'm going to allow for a 5-minute pause just to allow for translation of presentations 1 and 2 before I come to you, Tara and Butzte. So you're going to hear a moment of silence just while we do the translation process, and then we will resume.
Yanong kita sosobanya presentation yaga Dr. Gaina Parati yana tausa gor ubila dira di katomo kaka mokopane le Bushbuck Ridge ukopane le respika kopane me magrete me rotemfo atalosa gore konale matapa kamelau ya rona ya setso ga mmogo le masepala o le gore wa tsenela mo dilong tse re buang ka tsona. So o tlhalositse melao ya dimasepala tse leng teng yaka IDP bo Spuma yalo le yalo di social di SDF yalo le yalo ba gaetso ke lo tsala le tlhalosa. Mme o tlhalositse gape gore o dirile le the focus group ke di gona tsana a bereka le tsona gore di kgone gore di mo tlhalosetse go diragalang ka ka molao wa rona wa setho yalo le yalo mme o tlhalositse gore mme ga gona diphetogo dipe tse di rileng go simolola kwalo go fitlha ga jaanong yana ke a leboga.
Right. Thank you so much,
Recording in
Panelists.
progress.
Thanks for the patience to allow for translation. The next input is a co-presented paper by Tara Weinberg of the University of Michigan and Tembiso Kumbi of LARC at UCT. And they are co-presenting a paper that looks at communal property institutions and alternatives to CPAs. Tara and Ste, over to you.
Thanks, Melundi. Can you all hear me okay and see the presentation okay?
Yes, we can, Tara.
Okay, brilliant. So thanks very much, Melundi. Thanks to the organizers and colleagues here. So I'm going to begin and then Site is going to take over. So we're talking about communal property institutions, of which communal property associations, CPAs, are one example, one of the most common examples in the context of land reform. And community land trusts being one of the other most common forms of CPIs in the context of land reform. So in their best form, CPIs offer an alternative, or at least seem to the very narrow forms of property ownership that exist in common law. CPIs seem to offer a space in which people can have their local forms of property ownership and management recognized and supported. But in the implementation, CPIs have often been problematic structures. Often rightful beneficiaries of land reform have been excluded, and certain CPI members, traditional leaders, and government officials have used these vehicles, these legal entities, to enrich themselves. So in this presentation, I'm going to speak briefly to the history of CPIs and the implementation. I'm going to go back a little bit, covering some of my PhD research on the history of collective forms of property ownership in South Africa, to offer some ideas on antecedents to the CPIs that we've seen since the 1990s. And then my colleague Site Gumbi is going to reflect on issues that emerged with CPIs based on his research and experience in the Department of Rural Development and Land Reform, where he was the registrar for CPAs for several years. And Site is going to talk about some of the shortcuts taken, the lack of capacity for institutions like CPAs, the limits of trusts and CPAs as legal entities, and the issue of the government often privileging traditional leaders over CPIs. And then we'll end with a few ways that we propose out of the current CPI impasse, the CPI challenges that we see in South Africa at the moment. So first, briefly on CPIs in historical perspective. So communal property associations, CPAs, only actually came into being in 1996 through the CPA Act. And the Act was enacted specifically to enable communities to form juristic persons in order to acquire, hold, and manage property on a basis agreed to by members of a community and in terms of a written constitution. So CPAs were contemplated very much in the context of a land reform and a land restitution program in which often people had been dispossessed of their land as groups rather than only as individuals. And people wanted to come together and claim land back as groups and then take transfer of that title deed as a group rather than as individuals or individual families. And so CPAs were developed quite specifically to allow for that possibility. But collective forms of property ownership didn't just begin in the 1990s with CPAs. There's a much longer history to collective forms of property ownership in South Africa. And some examples of these are committees that were established for Black people who are buying land in the late 1800s and early 1900s, often before the 1913 Land Act. Sonobile and Nwana yesterday talked a little bit about land buying syndicates in the Northwest Province. Those are examples of communities in which committees were established to buy land and to manage land as collectives. There have been farmers associations and cooperatives. There were committees established in the context of struggles against forced removals. And there were also religious groups who would manage resources collectively. And these include women's groups such as Manyanos. So earlier forms of collective organizing set the foundation for communities, land activists, and lawyers to forge new juristic entities in the 1980s and 1990s for holding property as collectives. And these entities, CPAs, came about in part through struggles against forced removals, struggles from below. So I just want to give an example of a kind of antecedent to CPAs or to the collective property institutions we see today in South Africa. So some of you may be familiar with some of these communities. These are all places in which people came together and bought land as groups of Black farmers in the early 20th century. So Mogopa in the Northwest Province, Ditakwaneng in the Northwest Province, and Driefontein and Dachauer in what's now Mpumalanga Province. And in Driefontein and Dachauer, as an example, Black farmers came from around the country, from Natal, from Free State, from what was then the Transvaal, and they came together to buy land, over 200 families. They came together to buy land in 1912 with the assistance of lawyer and ANC founder Pixley Isaka Seme. And they did so through what they called a company of land buyers, which they called the Native Farmers Association. And it's interesting looking back at the articles of association written by Seme for the Native Farmers Association, where the articles of association really set out in detail the procedures of how this land buying syndicate would operate, including the nomination of the board members, initially all of whom were Black, the annual meetings that would take place, a quorum needed to make decisions, and how the company's shares would be distributed amongst the members. And residents in many of these places, including initially in Dachauer and also in Mogopa, asked to hold land in what they called undivided shares, which seemed to be an approximation of a kind of collective form of land ownership, but without a chief or traditional leader at the apex of the decision-making process. So committees were established for the allocation of land, for disputes around land issues, and so on. These are just some images that relate to what I was just talking about, Seme as a student from Bongani Nkulunga's excellent biography of Seme, and then Tutuka Dlamini in front of the house of his great-grandfather, Alex Dlamini. This was one of the first houses built in Dachauer when people bought land there in 1912. So then jumping ahead from some of the historical context to bring us up to the more recent past, in the early 1990s, land restitution is becoming a reality, and lawyers, land activists, and claimants are turning their attention towards a kind of property holding that would facilitate community or group ownership of land. And CPAs seem like an especially good fit in places where people had bought land previously, had established committees to manage land as collectives, places like Mogopa, Driefontein, and so on. Here are some images from the Wits historical papers out of the National Land Committee archive, National Land Committee, which was established in the 1990s, and which a lot of people here were also part of. And these were some early workshops held with often people who are part of communities that have been dispossessed of land over the past 100 years and were going to want to claim it back. And these were workshops held where people could map out what were the land rights that they or their ancestors had, what were the land rights that they would wish to have now, how would they be using land. So there was a process of mapping out rights geographically, but also kind of socially. And so when CPAs were established, those who were involved in creating the draft policy framework considered various forms of communal property institutions. I'm not going to go through the whole list, but there are some that I've listed over here. And they specifically realized that the South African Development Trust and tribal trusts, which made chiefs trustees in the former homelands, were problematic because they were apartheid era property forms that perpetuated this bifurcated land tenure system of individual title deeds for white people and chiefs controlling land for Black people. And so CPAs and communal property institutions were specifically developed as a way for people to realize some of the other forms of land ownership and land management that they had. I want to just touch briefly on one quote from Peter Mokomele, who is a land rights practitioner who worked for Anchor in the 1990s, and he would facilitate a lot of these early 1990s CPA workshops. And he noted that he would workshop with people the rules, and by rules and by law, he didn't mean something imposed from the outside, but rather—
5 minutes, Tara. 5 minutes.
Okay, thanks. But rather a way of embedding rules that had already been established in tradition, and writing those down. So, as he put it, the unwritten codes and how we come to follow them. So my final point before handing over to my colleague Sithe is that restitution was the coming into being of the Restitution Act and the Restitution Program in the 1990s was the catalyst for CPAs. But group property ownership is not something new. Something that's been around in South Africa for a long time. It's something that's very difficult. Like all forms of property, it involves dynamics of inclusion and exclusion. But that the CPA Act is a really interesting, remains an interesting mechanism despite its problems for allowing people to manage land as groups and for trying to give expression to some of the local forms of land tenure that people have. I'm now going to hand over to Sithe. And Sithe, I'll carry on doing the slides, so you can just tell me as you want me to change slides.
Thank you, Chair. Thank you, Tara. Tara has laid the foundation for our presentation. And I'm not going to dwell much on the trust because Kolos Santombini yesterday did a wonderful job in her paper. But I'm going to touch briefly on the trust, but my presentation will focus mainly on CPAs. There's actually been a raging debate about the best vehicle through which communities would co-manage the land that they receive from government. One of the anomalies about trusts versus CPAs is that they both receive land from the commission and from the department, but trusts are registered by the offices of the masters of the high courts, whereas CPAs are registered internally by the department. The problems which are endemic are the same in both institutions. And in 2012, the chief master approached the department with a view that all communal land trusts should be converted into CPAs. And the department agreed with the master's assertion about the problems with setting trusts, which are similar to those of the CPAs. And the legal opinion was sought and obtained from senior counsel Badlander. But it appears that the recommendations from that legal opinion may not have been implemented at all, if at all any of those were considered. We learned recently also from another workshop from an official from the office of the Chief Registrar of Deeds in Pretoria that they are amending the Deeds Registries Act so as not to allow any further community land trusts from being formed, which may have arisen from the request of the Chief Master. Can you move on to the next slide, please? It is still my view that given the current situation, the best vehicle that is available to communities could be CPAs. I base this from my experience when I was still working for an NGO in Pietermaritzburg called AFRA. Whenever we were talking to communities about how they will manage their land, this was the best model that, after explaining all the types of legal entities that were at their disposal, that people would always choose. Also, the CPA Act makes provision that the CPAs should be accountable. And also, it is a requirement that an annual report must be submitted on the performance of the committees and how they are managing the land on behalf of their members. And that is problematic because the trusts are not held to the same standards. Chair?
1 minute remaining.
I will have to then give to Tara then to propose the way forward, Chair, because we have quite a few slides that I wanted to go through. But that's a summary from myself. There have been quite a few studies, Chair, that I wanted to talk to, but it's in the presentation. And I think Tara will touch on what we propose should be done about those studies and the problems that have been identified in addressing the matter.
Okay, I'm going to ask Tara to take 30 seconds. I really want to leave at least a moment to get some engagement from members of the delegates who are attending. So Tara, if you could just close in 30 seconds, and then we're going to take some questions.
Sure. Yeah, my apologies, Site, on that being a short window. So Site and I talked about some of the ways forward with regard to CPAs. Some of them are based on what's already in the CPA amendment bill, and we've listed some of them here, but there are also problems with the CPA amendment bill that need attention. For example, the possibility that the state retains ownership over property and therefore that the CPA's role be downgraded. That would be a problem. In the high-level panel report and CSIR reports, there are also a bunch of very good suggestions on how to balance family rights with the rights of the group as a whole, accountability and capacity mechanisms, not to automatically privilege traditional leaders over CPAs, and to consider expanding the CPR registrar's capacity in office.
Thank you so much. Thank you, Tara. Thank you, Stay. My apologies for cutting you short. Time is always against us. Colleagues, we're going to take the in-person participation venues first. I recognize I'm not leaving you much time for translation, but with 15 or so minutes remaining, I'm wondering if you want to take 2 minutes to do a very quick summary translation of the input from Ooste and Tara. And then I'm going to come to Johannesburg first for questions and then to KZN. For those who are participating online, unfortunately, we won't get around taking live questions. So Anthony, I would ask that you put your input into the chat so that we can ensure that it's captured. So 2 minutes for translation, and then I'm coming to Joburg first for questions, and 2 questions per venue, please.
All right, bagaimana sih? Apa hubungan ka mola ulu role bela tu moja di CPIs. Kalau contoh susu banyak utilise di trust ka mola di CPA. Kalau kita mai sudah sama fase. Saya bagi bawa kalau pusu itu di shortcut itu kucuali. And then saya sing bawa kalau pusu kaya capacity kana hubungan kalau kabana. Ba tu baile kalau kau film baga kalau aku sama saya di tiro se. Sing kau nali go faila fo le fo me bane ba bua kapele le me khatlo kapele gore ke ba le biruwi go bua kapele ka di committee le gore di sele di simula di agiwa go tswa kwa lowe gore ba le beletsa masha mafatse ba buile kapele ka gore go tshwantse gore go be le ditirisanyo mmogo mo gareng ga rona batho le ga mmogo le tsona di committee tse go bua ka tsona go tswa kwa lowe ba gaetso ne ba bua gape gore ya ka di trust tse ba tlhalotsa gore di kwadisiwa ke mastera wa dikgotla tshekelo tse di kwa godimo, mme ba tlhalotsa gore di-CPA di kwadisiwa ke lefapha ke re bagaetso. And go bua gape gore go tshwanetse go fetole dilo tse tsa di-trust le CPA a ke ra bona gore ko bofelong e nne di-CPI. And ba tlhalositse gore Re Batlenda o bile a fana ka titsinyo ya semolao gore dilo tsa tse di tsamaisiwe yang jalo le jalo. Mme ko bofelong ga ke tswalela go tlhaloswa gore go tshwanetse go downgrade so the CPA.
All right, Joburg, are you ready for questions? Please go ahead with 2 speakers from Johannesburg. Can I ask Tara and Stay, I'm wondering if you might stop. Perfect, thank you. Johannesburg?
Goedgevonden community was forcefully removed, and we forcefully go back to our land in 1991. And then after that, we follow all the processes of forming doing our constitution, forming CPA and everything. We went step by step. And we also put in our land claims in 1998. But around 2000, everything changed. Around 2017, the government, the mafia government came and told people about the financial compensation. And we asked them, are we selling our land? They said, no, we are just giving you something for your pains. Only to find that they bought our land back and we don't have land. We also planned a peaceful march whereby policemen brutally attacked the community. So we don't know where to go, but we started the process with ARD. We done workshops and everything. So I don't know what's gonna happen with our land, because they say if we want our land back, we have to pay that 51 million back to the government. That was said by the Minister Tokoti Diza. Thank you.
Thank you. My name is Emily Charlie from Boomplatz farm, which we got in 2000. And 2001, we were given 2 title deeds, one in Afrikaans, one in English. What worries me, we followed all protocol. I can tell it as a protocol, all procedures. And even now, our people have not yet settled on the land because we were scattered in 4 regions of South Africa. But we tried to locate everything. We have the stands packed, everything. We have the business plan. We had a strategic partner. But when we were supposed to move in, now there is some interruptions. We must start again recently to go back and verify our households. So we are moving in circles. The department officials are so stereotyped, because when it comes towards the end of the year, they want bonuses. And in parliament and ministers, they should be seen working. So on the 25th, we are going back to Badplaats in Mpumalanga. I don't know what is the feedback, because now the president also, with the deputy minister, with the MECs, and the commissioner Nomfundo, they say they are doing the president what. So why go back in circles? What we should do is guerrilla farming if you don't have land, and go back. When we go back to our land, they said to us, we are invading. Can you invade your land? And why do they, when you do repossession, when they dispossess us, we do repossession, they say you will be arrested. For what? For your land. I'd rather die for a better land reform.
Thank you, Joburg. Can we come to questions on the chat? Our Durban colleagues don't have audio in their venue. So in the chat, a question from Durban is, what is the reason for failure of government for doing regulation on CPAs? Another question from Durban is, are mine employees or officials also allowed to be part of trustees? And then I would ask the panelists to also just keep an eye on the chat. There are a couple of inquiries and questions that are directed at you. So there's a question to Sther from Anthony around the real life difficulties that CPAs face, whether you've done a comparative analysis of CPAs and trusts, and whether there's any empirical evidence substantiating the recommendation that you make in support of CPAs. I'm going to ask Joburg, because the East London venue has had to take lunch early. Joburg, I'm going to ask if there is any other questions from your side before I go back to the panelists.
Chair, you want me to respond?
Just give Joburg a moment, Butste. Joburg, one final question from your side.
Thanks. Lina Lagaki Mashile Palani. CPA ya rena ya community abatlhabine hijackilwe. That means ke secretary Jerry CPA a dira ya gage le di plus jeo ka moka ke tša gage. So re dirane e le rena community. Thanks.
Thank you, Joburg. Is it possible to get a translation of Abut Mashile's input for the panelists?
Yeah, Mr. Mashile says actually, he says actually the CPA was hijacked and therefore now they are working alone. That's what he has said. So he says, what can they do as a community? That's what he's asked. He has asked. And then Emily was talking about the problems that of the land where they come from, that they followed the whole due processes, but unfortunately the land has not actually been given to them so far. So they must stand up and fight for their land, rather die. And then the Tandegale Kopa from Goedgevonden is talking that actually they were forcefully removed in Goedgevonden in 1991. Then in 2017, they were told about the issue of compensation, and then that the Minister Togotijisa said that actually for them to get their land back, they must pay back 51 million rand.
Thank you very much, colleagues in Joburg. All right, panelists, I'm going to come back to you for a response and or a closing remark. So I'm going to start with Ubutste, to whom one of the questions was addressed directly, then to Tara, to Professor Chakwizira, and then finish off with Professor Faye. So either a response to the questions as best you can, or a closing remark as best you can.
Thank you, Chair. I hope I understood the question correctly. I just want to say that the CPAs, there was a study done in 2005 by the CSIR about the problems of the CPAs. And this is what is now the department is implementing. They are doing what they call regularization of the CPAs based on that study, and other reports like the high-level panel also made certain recommendations, and as well as the panel of 2019. About the question from Durban, I think I've responded by saying they are regularizing the CPAs. And Mr. Mashile from Joburg, I will give Connie the contact person about the problem he alluded to. And also in terms of how CPAs have performed over the years from a chat, a question on the chat. People can go to the website of PMG, Parliamentary Monitoring Group, and they can see all the information there about the annual reports. Thank you, Chair.
Thank you very much. Thank you, Butste. Tara has indicated that she's happy for you to cover, to go to Professor Chakwizira. Your responses to the questions or a closing remark? Derek? Are
Yeah,
you
no, I don't
choosing?
have anything to add. Looking forward to reading the CPA written reports myself. It's no idea that those are actually publicly available. Thank you all.
Thanks, Derek. Nompilo, please can you mute yourself? Professor, thank you. Professor Chakwizera, are you there? Would you like to give a closing remark? All right. All right then. In that case, I'm going to bring this panel discussion to a close. There have been inquiries in the chat about the possibility of receiving the presentations. Some of the papers still need to be published before we can share the slides, but we certainly will reach out to all of the presenters and ask about their comfort levels with sharing their presentations, which will be made available to members of the conference. Tara is indicating they're happy to share their PowerPoint. Thanks, Tara. That's fantastic. All right, colleagues, thank you very much. Thanks for bearing with us through the glitches. My sincere apologies again to presenters. Time is never on our side. And it's not easy to rush you guys along. I know it's a bit disorienting. Thank you very much to everybody who joined this session. Please note that after lunch, we continue with running 2 parallel sessions. So again, you will return to the same link that you've used and make a choice to join one of the breakaway rooms. The conference will resume at 2 o'clock. Thank you so much.